Aylward was a peasant living in Westington, Bedfordshire during the mid-12th century. His legal troubles began with a mundane dispute common to any time: debt collection. Aylward claimed his neighbor, Fulk, owed him a debt. Frustrated by non-payment, Aylward broke the lock of Fulk's house to reclaim a whetstone and a pair of gloves as collateral. This act of self-help, which in modern court might be a civil trespass or petty theft, triggered a catastrophic chain of events. Fulk returned, accused Aylward of grand larceny, and had him arrested. In a world before the standardization of the jury, Aylward faced the judicium Dei, the judgment of God. He was sentenced to the ordeal of water. The scene is cinematic in its horror. Aylward was taken to a consecrated pool. A priest presided. Aylward was bound, likely thumb to opposite toe, a trussing known as the fetal position, to prevent swimming. He was then cast into the water. The theological setting was pretty stark. Water, the element of baptism and purity, would accept the innocent and reject the guilty. Sinking meant innocence. The water accepts the body. Floating, it meant guilt. The water rejects the sinner. Aylward, he floated. Because of his buoyancy, a matter of physics, lung capacity, and body fat, he was condemned as a thief. The punishment was immediate and irreversible. He was dragged from the pond to the place of execution. There his eyes were gouged out, his genitals were mutilated. This wasn't merely punishment. It was the erasure of his personhood. But trial by water was just for peasants. If you were a freeman, you faced the ordeal of hot iron. The ritual was precise. You fasted for 3 days. You entered a church. A priest, not a judge, heated a 1-pound iron bar in a holy fire. You had to carry it 9 feet. Your hand was then bandaged, sealed with wax, and inspected 3 days later. If the wound was clean, God had judged you innocent. If it was festering, you were guilty. Now, this sounds pretty insane to us, but scholars have found a hidden logic here. It was a psychological filter. The priests knew that only an innocent person, someone who truly believed God would protect them, would be willing to pick up a red-hot iron. So when a suspect stepped forward without fear, the priest often manipulated the test by letting the fire die down or interpreting a blister as a healing wound. It was a system that worked, but only because everyone believed the lie. Now, why would everyone go along with this lie for centuries? Historians analyzed a registry from Hungary in the 13th century that tracked 308 of these trials, and they found a fascinating statistical anomaly. The majority of people who were threatened with the iron never actually touched it. When faced with the heat, the guilty, terrified of being burned and damned by God, would usually confess or settle. Only the innocent, who truly believed a miracle would save them, were willing to step forward. This created what economists call a separating equilibrium. By the time you actually grabbed the iron, you had already proven your faith in your own innocence. The priest wasn't testing your skin, he was testing your conviction. It was a brilliant, terrifying psychological trap. But it had one fatal flaw. It only worked as long as you believed in miracles. And in 1154, a new king arrived who didn't care about miracles. He cared about justice and administration. What I'm describing isn't a horror movie. That was English justice in the 12th century. And the reason you don't live in that world today is largely one man, King Henry II, the king who helped invent the machinery we still use today. Juries, indictments, and a common law that binds the powerful and protects the ordinary. King Henry II didn't just reform courts, he rebuilt the very idea that law could be rational, public, knowable, and shared. He awakened the idea of individual moral agency. But Henry's legal genius came with a personal catastrophe. His crusade for order helped trigger the murder of his closest friend, Thomas Becket, and his own family would later turn on him. This is the story of how modern law was born out of personal chaos. King Henry II Plantagenet came to the throne of England in 1154, and he inherited a realm in chaos. The previous decades had been a lawless free-for-all due to civil war, the anarchy under King Stephen. Barons had seized power, local lords dispensed their own justice, and the rules could change from shire to shire. The period historians call the anarchy was a collapse of legal authority. With no uncontested king, England fragmented into hundreds of miniature regimes. Barons built unauthorized castles, ran private courts, and enforced justice by force rather than by law. Historians famously wrote that Christ and his saints slept. But they didn't just write about spiritual abandonment. They wrote about the technology of torture. The Anglo-Saxon Chronicle describes the Creuset House, a chest that was too short and narrow for a human body, filled with sharp stones. Men were crushed inside until their limbs broke. It describes the saccentage, a spiked iron collar fastened to a heavy beam. A prisoner locked in it could never sit, never lie down, and never sleep. They just had to stand, bearing the weight of the iron, until they paid their fine. This wasn't just a civil war, it was a total privatization of violence. Every castle had become a torture chamber, and every local lord had become a tyrant. This is the wreckage Henry II inherited. He didn't just need to win a war, he needed to build a machine of justice that could crush these local tyrants. Before Henry's reign, laws varied widely by region, and justice was often arbitrary. One lord might let you buy your way out of trouble, while another might cut off your ear for the same offense. There was no consistency, no law of the land. It was the law of whichever lord you stood before. Henry, young and determined, saw the mess and sought to fix it. He envisioned a unified legal system that would be the same for all of England. In a time when the concept of equal justice was almost unheard of, Henry's vision was radical. His weapon of choice wasn't a sword, it was a piece of parchment called the Writ of Novel Disseisin. Take the case of Richard of Sudbury. He was a commoner. The Countess Amise, one of the most powerful women in England, kicked him off his land. In the old world, Richard would have been crushed, but under Henry's new system, he bought a writ. This document didn't ask complex legal questions. It commanded the sheriff to ask 12 local neighbors a simple factual question. Was Richard occupying the land there? And did the Countess kick him out? The neighbors said yes. The sheriff immediately marched Richard back onto his farm and fined the Countess. This was the revolution. The king was using the community, the jury, to protect the ordinary man from the warlord. And you could do it for the price of a piece of paper. This was the quiet revolution. Henry didn't stop the Creuset houses and the sacentages of the anarchy just by besieging castles. He stopped them by offering a better product. He made the royal court cheaper, faster, and fairer than the baron's torture chamber. He didn't just ban the violence, he made it obsolete. Importantly, Henry II was not just King of England. He ruled a vast empire stretching through much of France, thanks in part to his savvy marriage to Eleanor of Aquitaine. He was one of the most powerful men in Europe. But to keep that power, Henry needed order and loyalty at home. One way to get that was through a fairer justice system that didn't solely favor the nobles or the church. Henry famously believed that justice should be the same for every man, whether rich or poor, a surprisingly forward-thinking idea for the 1100s. So he set out to tame the feudal chaos with a series of legal reforms. Henry traveled incessantly between his territories, governing on the move. One chronicler wrote that Henry devoured the distance with his energy. He was known for his fiery temper and restless intellect. This was a king who personally got involved in government, not one to sit idle on a throne. And when it came to the legal system, Henry had a hands-on approach. He would send out royal officials, assert the crown's authority, and standardize legal procedures. No more trial by random chance if he could help it. To appreciate just how bold Henry's changes were, we need to understand what he was up against in the existing legal culture. In the old medieval system, the verdict on your case could depend on a supernatural sign. Ordeal by fire, ordeal by water, or a duel to the death. These were normal legal trials. The underlying belief was that God would not let an innocent person suffer unjustly. If you survived the flames or the fight, it meant God vindicated you. Of course, common sense tells us this was horribly unreliable. Innocent people could and did die in ordeals. Even in the 1100s, it wasn't lost on educated folks that ordeal and combat were barbaric. Henry II certainly thought England could do better. One of Henry's biggest innovations was introducing the concept of jury trials to replace these trials by ordeal and by combat. Rather than leaving the decision to a miracle or duel, Henry's system would use these crazy inventions called evidence and testimony. Under Henry, a group of local men, a jury, would be sworn to tell the truth about a case and render a verdict based on facts. This was a massive shift towards rational, evidence-based justice. In the 1160s, Henry issued the Assize of Clarendon, which is a fancy way of saying a royal decree that established a new judicial procedure. The Assize of Clarendon is famous for laying the groundwork for the jury system. It required that in each area, a group of 12 lawful men under oath would consider the names of any local people who were suspected of serious crimes. This was essentially the first grand jury. They presented indictments. Under Henry's early system, if the jury of presentment accused you of a felony, you would then be sent to trial by ordeal of water to determine guilt. Henry wasn't able to abolish ordeals overnight, but even with ordeals still around, Henry's use of a jury to investigate was a game changer. It meant community members' sworn testimony started to matter more than supernatural signs. It was the beginning of the end for trial by ordeal. And what about trial by combat? Henry II took steps to curb that too. Trial by battle had been introduced to England by William the Conqueror in 1066, and over time it was available in certain civil and criminal cases. Henry found it impractical and encouraged peaceful adjudication. He limited trial by combat to a much narrower set of cases, notably certain serious criminal appeals and one specific type of property lawsuit called a writ of right. But even in those, he offered alternatives. For example, in disputes over land ownership, writs of right, Henry introduced an option to have the case decided by a special jury of knights, the Grand Assize, instead of by combat. This meant a landowner who didn't fancy a sword fight could opt for a jury trial before the king's judges. As a result, trial by combat became increasingly rare. It never disappeared overnight. In fact, it lingered in English law for centuries, as we'll see later. But Henry's reforms made reason and proof begin to triumph over violence and chance. Henry's quest to reform the legal system wasn't just about courts and juries. It also brought him into a colossal clash with the church. In medieval Europe, the Catholic Church was immensely powerful and had its own separate justice system. Clergymen accused of crimes could claim benefit of clergy and be tried in special church courts, where punishments were often more lenient. It didn't sit well with Henry. Henry believed that everyone in his realm should answer to the king's law. The church, however, acted like an independent kingdom within the kingdom, an imperium in imperio, as historians say. Church courts were beyond Henry's control, and that meant a murderer in a monk's robe might escape the harsh justice of the crown. Henry wanted to plug that loophole and ensure even clergymen who committed serious crimes faced royal justice. To achieve this, Henry, in 1164, promulgated the Constitutions of Clarendon, attempting to restrict ecclesiastical privileges and making clergy more accountable to secular courts. He expected his hand-picked Archbishop of Canterbury, Thomas Becket, who had been Henry's close friend and chancellor, to support these reforms. Instead, Becket became an unexpected champion of church independence. The conflict between king and archbishop turned into high drama. Becket fled into exile, bickered with Henry in letters, and was eventually allowed back to England, only for their feud to reach a tragic climax. On a chilly December day in 1170, in Canterbury Cathedral, 4 knights loyal to Henry confronted Archbishop Becket. Henry, in a fit of rage, allegedly shouted,
"Will no one rid me of this meddlesome priest?"
And these knights took it literally. They murdered Becket at the altar, shocking all of Europe. Henry II hadn't explicitly ordered the killing, but his angry words set it in motion. The result was a public relations disaster for the king. Henry was forced to do penance, famously walking barefoot to Becket's tomb and letting monks flog him to atone for the incident. Becket was venerated as a martyr, and Henry's hopes of immediately subduing the church were dashed. Before this became a clash of crown and church, it was a personal rupture. Thomas Becket was not Henry's enemy by nature. He was Henry's creation. As Chancellor, Becket had been the king's drinking companion, hunting partner, and ruthless enforcer, a man who wore silk, hosted lavish banquets, and advanced royal power with enthusiasm. Henry elevated him to archbishop precisely because he expected loyalty. But instead, the transformation was dramatic and unnerving. Once consecrated, Becket abandoned luxury, adopted austere habits, and recast himself as a defender of ecclesiastical liberty against the very king who had made him powerful. To Henry, this felt like betrayal masquerading as piety. To Becket, it was obedience to a higher law. What made their conflict so explosive was not merely theology or jurisdiction, but intimacy. Henry felt defied by a friend, and Becket felt compelled to resist a ruler who once trusted him completely.
I would have given away my life laughingly for you. Only I loved you, and you didn't love me. That's the difference.
The struggle was not just institutional, it was tragically personal. However, the long-term outcome tilted in Henry's favor. The outrage over Becket's murder pressured Henry to compromise with the church. Ultimately, some of Henry's aims were achieved in later years. English kings gradually limited the church's legal authority over the clergy, but in 1170, the Becket affair showed just how controversial Henry's legal reforms could be. He was challenging centuries of tradition and powerful interest, and that was bound to spark conflict. In a way, Henry's fight with Becket is an early chapter in the story of separating church and state in the legal sphere. In an age when church and crown governed nearly every aspect of life, the idea of choosing one's own faith was virtually unthinkable. Henry II's 12th century England presumed religious unity. Indeed, the king was expected to enforce conformity in the realm's faith. Personal belief was not a matter of free choice, but of allegiance to God as mediated by the church and to the crown upholding the church's authority. Against this backdrop, Henry's clash with Thomas Becket over the limits of royal power takes on a profound spiritual dimension. It wasn't merely a political quarrel, but a collision of worldviews about who held ultimate authority over the soul. Becket championed the church's libertas ecclesiae, its liberty to govern its own and guide the fate of souls without royal interference. Henry, for his part, believed in unified order where even the clergy answered to the law of the land. This tension raised a timeless question. Do individuals have agency over their own souls and convictions? Or are these fundamentally subject to institutional power? Medieval society largely assumed the latter. Souls were shepherded by the church, and the path of salvation was beyond individual control, yet Becket's stand hinted that conscience and principle could drive a man to resist even a king. The importance of freedom of choice and faith flickers here as an embryonic idea. In Becket's martyrdom, we see an assertion that obedience to one's faith and God's law stood above obedience to any earthly ruler, a stance that would echo through history as the seed of a later doctrine, that true faith cannot be compelled. Drama aside, let's dive into how Henry II's reforms actually worked and why they were so influential. Henry didn't just tinker at the edges. He rebuilt the English legal system in several fundamental ways. Henry established a unified common law for all of England. This means that instead of each region following its own customs, there was one set of royal legal rules applied everywhere. Henry achieved this by sending royal judges on circuits around the country. These judges traveled from county to county, hearing cases in the king's name. They brought consistency. A murder or land dispute in York would be handled under the same principles as one in London. Over time, the decisions of these royal judges were written down and referred to in future cases, creating a body of precedent that everyone could draw upon. This was revolutionary. Before Henry, there wasn't really a concept that the decision in one case should guide another. Henry's system recorded and reused legal principles as precedent, laying the groundwork for the idea that the law is a growing, evolving thing built on past decisions. The concept of precedent that courts should follow earlier judicial decisions, is the cornerstone of common law, and it started here in Henry's reforms. It made the law more predictable, more fair. People could know what the law was by looking at earlier cases rather than being subject to a lord's whim. Before Henry, if you wanted justice, you often had to appeal to your local feudal lord or a church court. Henry changed that by greatly expanding the jurisdiction of these courts. He and his successors set up courts like the King's Bench and Common Pleas in Westminster. But crucially, Henry didn't make everyone travel to him. He brought justice to the people. He appointed justices in eyre. Eyre means journey, essentially circuit judges, to regularly tour the shires. They would show up in a county, hear all the serious cases, and enforce the king's law. This had a unifying effect. Local barons could no longer monopolize justice, and the king's law reached into every village. It also meant access to justice improved. Even common folk could bring a case before the king's judges without trekking to the capital. Henry opened up the royal courts to ordinary people, which was a big step toward a more inclusive legal system. For example, if a free tenant felt wronged by a lord, he could try to get a royal writ and have his case heard by a royal judge instead of the lord's man. Speaking of writs, a writ was a short written order from the king, essentially a ticket to get your case heard in the royal courts. Henry II and his government became writ-making machines, devising standardized writs for different situations. Arguably, the most famous was the writ of novel disseisin. Novel disseisin meaning recent dispossession, a game changer in land disputes. If someone forcibly evicted you from your land, instead of gathering your swordsmen and starting a private war, you could purchase a writ of novel disseisin from the royal chancery. That writ would command the sheriff and a royal judge to convene a jury of locals and ask one simple question: was the plaintiff recently and unlawfully dispossessed of land? If the jury's answer was yes, the land was immediately restored to the plaintiff. No lengthy feudal appeal, no duel in the courtyard. The brilliance of this writ was that its speed and simplicity. It avoided the usual delays and technicalities of feudal justice and cut straight to the core issue. Were you kicked out unjustly? It became very popular because it provided quick relief. Think about being a medieval farmer and suddenly having this tool to get your property back through a court order rather than by force. It was almost like magic. For a medieval farmer, this wasn't legal theory. It was the difference between keeping your land or losing your livelihood. In fact, Henry's writs, including novel disseisin and related one like mort d'ancestor for inheritance disputes, were so effective that they remained in use for centuries. The assize of novel disseisin wasn't abolished until 1833. Henry also commercialized justice in a way. For a fee, anyone could get a royal writ and access the king's courts. This brought revenue to the crown and justice to the people, a win-win for Henry. To truly appreciate how radical a system of speedy justice was, you have to look at the user experience just a few years prior. We have the surviving diary of a man named Richard d'Anstey, who tried to claim an inheritance in 1158 before the reforms fully took hold. His diary is a ledger of despair. Because there was no fixed court, Richard had to physically chase the king's court across Europe. He crossed the English Channel multiple times, following Henry from Normandy to Gascony, just to get a hearing. He waited in hallways for months. He spent a fortune on horses, ships, and bribes, eventually forcing him to borrow vast sums from moneylenders at ruinous interest rates. It took him 5 years to get a judgment that should have taken 5 days. Henry realized that a justice system you can't find is no justice system at all. So he inverted the map. He created the eyre we talked about, traveling judges. For Richard d'Anstey, justice was a 5-year odyssey. For the generation that followed, it became a local and quick appointment. We've touched on this, but Henry's reforms made trials more about facts and less about faith. Under Henry, the use of juries expanded. For civil disputes, Henry's courts would often summon 12 local freemen to swear an oath and answer questions about the case, acting as both witnesses and judges of fact. This was the early form of what we now think of as a trial jury. For criminal cases, Henry's grand jury, jury of presentment, would accuse people, and then guilt might still be decided by ordeal, later in that time. But Henry set in motion the process that would replace ordeals with jury verdicts. In 1215, when the church banned clergy from participating in ordeals, trial by ordeal could no longer function. Henry's system was ready to fill the void. By the early 13th century, courts moved straight to trial by jury to determine guilt or innocence. This was a direct evolution of what Henry had started decades earlier. The jury trial, which Americans cherish as a constitutional right, has its roots in Henry II's 12th century innovations. He didn't invent the idea from scratch. Juries of local men were used in earlier times for certain purposes, but he regularized it and expanded it into the central feature of the legal process. No longer would a cleric's whim decide every case. Instead, your neighbors in the jury box would. The shift toward evidence-based verdicts is one of Henry's greatest contributions to legal history. Henry's judges also kept records. Notably, Henry's chief justiciar, basically his head judge minister, Ranulph de Glanville, wrote a treatise on the law of England around 1188, the first of its kind. Over time, the rulings of the king's courts were compiled. Future cases would refer back to what was decided before, and precedent was born. The consistency was a radical improvement. Rather than each new dispute being a blank slate, judges and litigants could say, hey, in Smith versus Brown last year, we decided this kind of issue this way, so let's do it the same. It created what we call the common law, a law common to all and built case by case. The idea that the past informs the present in legal decisions is something we take for granted now, but in Henry's time it was emerging anew. The common law system that Henry II established still underpins the legal systems of England, the United States, and many other countries today. Every time a modern lawyer cites an earlier case as precedent, they're paying indirect homage to Henry's legacy. Henry II didn't accomplish all of this overnight or alone, of course. These reforms rolled out through various decrees, the Assizes of Clarendon, Northampton, and so on, and with the help of educated clerics and knights in his administration. There was resistance along the way. Some barons grumbled at losing their judicial powers, the church resisted encroachment on its privileges, and the common folk needed to get used to a newfangled system. But by the end of Henry's reign, the foundations of English common law were firmly laid. Royal justice was now a fixture of daily life, and trial by combat and ordeal were on the way out, or at least confined to the margins. Beyond the legal reforms themselves, Henry II's legacy hints at a deeper philosophy of the common law, a view that the law is more than a set of rules, but a framework of justice, order, and personhood. The system he built was revolutionary in that one law applied to everyone, from peasant to lord, replacing a patchwork of feudal customs with uniform principles common to all. Henry's judges traveled on circuits to ensure that royal justice reached every shire, and in doing so they began applying uniform rules and following the guide of recorded precedent in similar cases. This meant that the common law was not only centralized, but also cumulative, growing case by case, carrying the memory of the past judgments. In this new legal culture, disputes came to be settled by evidence in jury deliberation, instead of supernatural trial or private vengeance. Trial by ordeal and combat gradually gave way to trial by jury, signaling a shift from verdicts believed to reflect God's will to verdicts reached by ordinary people weighing facts. Such a change implied a burgeoning trust in human agency and reason. Sir Edward Coke later captured this ethos when he observed that the common law itself is nothing else but reason. The common law thus embodied a worldview. It treated individuals not as helpless subjects, but as rational actors, bearers of rights and duties, who could be called to account under a law that was knowable, rational, common to all. Henry's legal revolution, in short, was more than an administrative overhaul. It reflected and reinforced a vision of society as a community of free persons bound together by a shared pursuit of justice, where order is maintained not by the caprice of rulers, but by principles that emerge from the community's own sense of fairness and precedent. Ironically, even as Henry II was building a more orderly legal system, his own family life was the stuff of a chaotic soap opera. Perhaps the rule of law had better footing in Henry's courts than in his household. Henry's marriage to Eleanor of Aquitaine was passionate but tempestuous. Eleanor was a powerful woman in her own right, the Duchess of Aquitaine, former Queen of France, and one of the most influential figures of the age. Together, she and Henry had a brood of sons who had become famous or infamous. Richard the Lionheart, young Henry, the Young King, Geoffrey, and John, later known as King John of Magna Carta fame. Henry, hoping to secure his dynasty, had his eldest surviving son, Henry, crowned as co-king during his own lifetime. But the young king wanted real power of his own. Soon enough, Henry's sons rebelled against him. Egged on by their mother Eleanor and by King Louis VII of France, who happened to be Eleanor's ex-husband, this became the Great Revolt of 1173 to 1174, a full-blown family and nobles rebellion against Henry II. You can sense the drama. Queen Eleanor plotting with her teenage sons to overthrow their father, knights and castles switching allegiances, and Henry II racing to put out fires across his empire. The rebellion saw fighting in England and Henry's French territories. At one point, Henry's enemies even enlisted the King of Scotland to invade England from the north. But Henry II, ever the energetic leader, managed to quash the revolt. He captured William, King of Scots, and astonishingly captured Eleanor as well. Yeah, he locked up his own wife for her role in the rebellion. Eleanor would spend about 15 years in semi-captivity for crossing Henry until he died. By 1174, Henry had forced his sons and barons to submit. The family reconciled outwardly, but it was a bitter peace. This family feud wasn't the last. Henry's sons kept chafing for power, and Henry the young king even died of illness while rebelling again. Later, Richard, Henry's favorite son turned nemesis, allied with the French king to wage war on his father in the 1180s. In 1189, beaten and heartbroken by Richard's betrayal, Henry II died, supposedly lamenting that even his own children had conspired against him. It's a Shakespearean tragedy that while Henry was reforming the law and promoting a real sense of justice, his personal world was lawless, cruel, and crumbling. Betrayal, rebellion, and bloodshed marred his final years. Eleanor of Aquitaine, after Henry's death, would help Richard the Lionheart rule, and then survive long enough to see King John sign the Magna Carta in 1215. But that's another story, maybe for another day. The key takeaway for us is that despite the turmoil, Henry II's legal reforms endured. Kings and queens would come and go, feuds would flare and die. But the common law Henry planted kept growing stronger. In fact, some historians say Henry's legal innovations are the greatest monument of his reign, more lasting than any castle he built or battle he won. Henry II never imagined a world of smartphones, democracy, and courts on YouTube.
I'm here live. I'm not a cat.
I can see that.
But his influence is still very much alive today. Henry's 12th century reforms became the basis of the English common law tradition, which was later exported worldwide, including to North America. When the United States was founded in the 18th century, its legal system didn't start from scratch. It was built on English common law principles, the very principles Henry helped establish. The idea that precedent guides judges? That started with Henry. The use of juries in both criminal and civil trials? That was formalized under Henry. Even the concept that courts are open to ordinary people seeking justice against the powerful has a lineage back to Henry's reforms. Next time you sit in a courtroom or watch a legal drama, remember that the scripted phrase,
"Ladies and gentlemen of the jury,"
has its roots in medieval England, when Henry's reforms allowed 12 good men to decide cases instead of God's judgment by fire or water. Perhaps the most direct through line from Henry II to today is the common law itself, a living body of law that evolves case by case. Common law is why American judges often cite not just statutes and constitutions, but also earlier court decisions. That practice of citing cases started as soon as Henry's judges had a few years of decisions under their belts and look back to see how previous judges ruled. It's pretty amazing that a 12th century king's legal revolution still shapes the lawsuits and trials of the 21st century. Henry II's reign has been called the birth of the English state because his legal and administrative reforms knitted the country together in ways that have never entirely unraveled. The authority of law, as opposed to the arbitrary will of rulers or local lords, is part of that legacy. And what became of those bizarre medieval trials we opened with? Trial by ordeal was formally ended in 1215, thanks to the church's intervention. A few years after Henry's death, the Pope declared priests should stop overseeing ordeals, effectively killing the practice. Trial by combat, however, hung around much longer as a legal option, but it was rarely used. The last trial by combat in England didn't happen until the 19th century. In 1817, a murder suspect named Abraham Thornton asserted his ancient right to trial by battle when faced with an appeal, a type of private prosecution, for murder. Thornton literally threw down a gauntlet in court, challenging the accuser to pick it up and fight. And since trial by combat was technically still on the books, the court had to allow it. The victim's brother, the accuser, declined to fight, perhaps not eager to engage in some medieval duel. And under the old rules, that meant Thornton went free. This outcome caused an uproar. The public was outraged that in modern times, a murderer might escape justice through such a loophole. So, in 1819, Parliament abolished trial by combat and private appeals of murder for good. Thornton's case was the last hurrah of trial by battle in English law, and its absurd result ensured no one would ever get off the hook that way again. So the echoes of trial by combat remain even today. The idea is so theatrically fascinating that it pops up in popular culture. Thank you, Game of Thrones. And occasionally in real-life courtrooms as a tongue-in-cheek request. In a few modern cases, parties have tried to demand trial by combat, usually to make a point or gain publicity. In one 2020 case, for example, a man in Iowa formally asked a court to let him and his ex-wife settle their dispute by a sword duel on the field of battle. He cited the lack of explicit prohibition of trial by combat in American law. An imaginative argument. But needless to say, the judge refused. Even more famously, in early 2021, Rudy Giuliani provocatively called for trial by combat during a rally, implying a fight over election results. He later claimed he was speaking metaphorically about Game of Thrones, not actually encouraging people to duel, but the phrase grabbed headlines. These episodes show how the medieval past lingers in our language and imagination. We're captivated by the image of two champions battling for justice, even if we no longer allow it in our courts. And that contrast between the old ways of settling disputes by combat or ordeal and the new way of law and evidence is exactly what makes Henry II's story so compelling. In the grand tug of war between might and right, Henry helped tilt the balance towards right. He replaced trial by fire with trial by jury, and might makes right with legal precedent and evidence. Henry II's common law was a system where ideally the same rules applied to peasant and lord alike, and where royal courts could overrule feudal injustice. It wasn't perfect. Medieval justice was still harsh, and we wouldn't want to live under all of Henry's laws. But it was a monumental improvement that set England on a course distinct from much of the world. While continental Europe often stuck with trial by ordeal, a bit longer or later adopted Roman law codes, England pursued this common law path that valued local juries and case precedent. Henry II reforms also did something subtle but profound. They changed the moral center of gravity of authority. Under ordeal and combat, the individual is basically a pawn. Your fate turns on brute force, superstition, or the whim of whoever has the most swords. But a jury, a writ, and a public court assumes something different, that ordinary people can be reasoned with, that facts can be weighed, and that even power must speak in the language of rules. This is an early form of personal sovereignty, not modern libertarian autonomy, but the older idea that a person is not merely owned by the strong. You are a rights-bearing actor who can invoke a process, demand a hearing, and force the powerful to justify themselves in public. The king is still the king, But he is no longer merely a hammer. He's increasingly a judge, and judges by definition are bound to something outside themselves. We're a long way from testing the truth with fire and ordeals. That shift matters because it lays a track that later thinkers will ride straight into the modern world. Once law becomes something knowable and general, a thing you can point to, invoke, and expect to be applied consistently, you get a new question that medieval England wasn't ready to answer, but couldn't unask. If law is supposed to be common, rational, and public, then what makes it legitimate? Is it legitimate because the king says so? Or because it tracks something deeper? Custom? Reason? Or the inalienable rights of the people who live under it? The English tradition gradually starts to speak in that second register. The Magna Carta will later declare, in effect, that even the king is under the law. And by the time you get to the American founding, that logic is basically weaponized. Governments exist to secure rights. They're accountable to the people. And when they become destructive of those ends, the people may alter or abolish them. The Declaration of Independence doesn't come out of nowhere. It's the rhetorical culmination of centuries of legal development in which rule by will is slowly forced to compete with rule by law. Henry's legacy isn't in statutes or battles. It's in the machinery we still use today. Every time a defendant enters a plea, instead of grabbing a hot iron, every time a jury is sworn in, every time a judge cites precedent, that's the engine of Henry II running in the background. We don't have a perfect system, but because of the work done in the 12th century, if you're accused of a crime today, you won't face the pond and you won't face the iron. You will face your equals. And that's the difference between magic and justice, between tyranny and justice. King Henry II's machinery did more than just settle disputes. It planted a seed. The protections Henry forged would eventually cross the Atlantic to become the rights demanded by the American founders. This legal revolution paved the way for the natural rights revolution of 1776, transforming the king's justice into the people's shield. In the coming year, 2026, we will explore that foundation on this channel, tracing the golden thread of liberty from the anarchy of England to the Constitution of America. I hope you'll join us, and I wish you a splendid new year.